When someone has a passion for what they do, it comes through in the product they provide their customers. Just ask LaRocco's Pizza's new owner, Jason Johnson, about their crust. They make it every day and let it rise for a minimum of 24 hours before they use it for their pizza. And his staff doesn't want to do anything they won't be the best at, and you can taste it in their pizza. LaRocco's Pizza, just a half block north of the I-470 and Gage Boulevard exit. Come taste the difference.
It's the season for brand new mulch, and Brown's Tree Service has got your yard covered. Brown's Tree Service utilizes hardwood mulch that retains more moisture. Not only does mulch make your yard more appealing, it also reduces weeds, improves soil, and creates insulation for plants. Get the right mulch for your job at Brown's Tree Service. They shred it, haul it, and spread it in bulk. Or you can haul it yourself for the personal touch to your property. Call Brown's Tree Service at 785-379-9212 or visit online at brownstreeservice.lc.com.
It's time for Real Estate 101 with the Carrie Brown team from Preferred Advisors.
Good Saturday morning to you. This is Carrie Brown, Associate Broker with eXp Realty and the Preferred Advisors team, and you're listening to Real Estate 101. I am back with my co-host for the month, Scott Sexton from the Law Office of Scott Sexton. How are you this morning?
I'm doing good. How are you?
I am good. We have covered a lot of ground on this show, so I went to my trusty Google and said, okay, what are the things have we not covered? One of which I've actually seen happen before, and I want your opinion on it. A gentleman had created a will. He put his desires in it for his will in a secured lockbox at the bank, but he never recorded it anywhere. Is that considered to be binding?
It can be, yes. A will in the state of Kansas is not required to be on file after you've prepared it. It only needs to be filed for preservation if an individual passes away. So if that lockbox was in the possession of a third party who knew that the deceased had passed away, and then they may be responsible for making sure that the next of kin or whoever the interested parties are get a copy of that will and work to file that with the appropriate court or legal authority, which is again one of the problems and shortcomings of having just a will and locking it away in your lockbox is that it can be difficult at best sometimes for a family to track down that will unless they knew explicitly, hey, look, it's at this bank, and if something ever happens to me, you need to have this lockbox key to be able to get access to it. So putting your will in a lockbox and just expecting the family to track that down when they need it most isn't the most reliable way to do that. I always advise clients to have electronic copies of those types of important documents. Make sure that everybody has an emailed copy on their phone that they can pull up in a pinch if something were to happen. So do they need to file it in order to, while they're alive? No, but you do need to have a will filed for preservation after you pass away.
Does it make it easier to contest if it was not recorded in any place?
It can be. It depends a lot on the circumstances of the given case. Why are people actually trying to challenge this will? But it is a requirement in the state of Kansas that if you want to enforce the terms of a will, it must be filed. And typically, and again, this is a sliding scale, unfortunately, in the state of Kansas, especially in light of COVID-19. Typically, you need to have a will filed within 6 months of a person's passing. However, there may be circumstances that require you to file it sooner or later. It just sort of depends. Again, I would always emphasize if you have a loved one that passes away, you need to be talking to an attorney immediately if there is a will that you know exists that needs to be preserved. So speak to an attorney right away about getting something like that filed with the district court.
One suggestion I would make, and I know not everybody is super organized. My dad wasn't. But he was he was really clear about what his expectations were. And I won't say that he left me a mess. I will say that he didn't make it necessarily easy. Is put together a binder. Okay, insurance policies, any kind of financial things that someone should know, like where the bank accounts are. I didn't live in the same state anymore, so I wasn't really aware of where things were because, towns grow and boom and some places close and all that good stuff. We actually had a life insurance policy show up to be made payable 10 years after he passed. Nobody even knew it existed. So there are things that it would be really great to put in a binder and have it in a secure place, like in either a home safe or at a bank or something like that, so that your family doesn't have to hunt for it. I mean, yes, it was a welcome surprise, but at the same time, it's like, what if we had debts that we needed to pay off? We didn't even know that existed. So that's where that comes into play. It would be good to know.
Absolutely.
And for your, not even talking about passing away, but let's just say you get really sick. He had a cancer policy that helped to cover expenses. If it had been left up to us, we wouldn't have even known that existed. So, and whenever you're on morphine at that point, he had renal cell carcinoma, which is kidney cancer, and had some very serious surgeries. He wasn't always him. So I would say that needs to go on a binder too, not just the things that are relevant to if you should pass away, things that they need to know right now.
Yeah. And I would go one step further. It's also important to circulate that information if at all possible, because you could have the best binder in the world, but if it's locked away in a hidden safe underneath your bed and the kids don't know about it, it's still not going to do them any good. And so part of anytime I'm designing an estate plan, that's one of the very first things that we have on our intake is we need you to bullet point out all of your financial records for me, if at all possible. But not because I'm curious about what you do or don't have. My big concern is I want to make sure that if something happens, we have a proper accounting of where everything's at. Where do we need to track down assets, and what effort we don't have to track down. So it certainly makes it easier not only for the family, but it can also make it much more affordable for the family in the long run if they don't have to pay someone like me to go and play detective to track down all of their loved ones' assets.
Absolutely. And I know that, this is a world where people, like me, I'm a real estate agent. I work on commission. Attorneys, people often don't know whether they should trust us right off the bat, even though our intentions are pure. There are people before us or around us that may have made that a little difficult to trust. But if you're going to employ someone, I'm just going to use me as an example, so I don't make you uncomfortable. But the reason why I ask the questions that I ask, like, have you gotten a loan? Have you talked to a lender? Have you looked at your credit score? Can I help you with that? Things along those lines, is because it's my job to help you. If you want my help, I need to know all of the facts, not because I would ever judge you in any way, form, or fashion, because that's just not me, but because I want to make sure I do the best job possible. And that would be the same way with Scott, You want to be able to do the best job possible, and that means asking those uncomfortable questions.
Yeah. Absolutely.
What properties can you put into a living trust?
Real quickly, just to define living trust, a living trust is typically a trust that is designed and executed while a person's alive. That's why we call them living trusts, as opposed to a testamentary trust, which is only created through probate or through a will. And so living trusts can hold just about anything that a normal, living, breathing human being can own. So they can own real estate, they can own bank accounts, they can own investments. The big kind of ticket items that you want to be careful with are IRAs and 401ks. Under the Internal Revenue Code, and a trust is prohibited from owning those types of retirement accounts. And so it's important that we kind of keep an eye on those accounts, because some people mistakenly believe, oh yeah, my CDs are in my trust, when in fact they're not in the trust, because while they are in CDs, it's actually an IRA account. And so the bank wasn't able to put that money into the trust. And if we don't have a beneficiary in it, there could be a problem. So the simple answer is you can put just about anything you want into a living trust, but you cannot put IRAs or 401k type accounts into it, because they're prohibited under the Internal Revenue Code from being held by anything other than a natural, living, breathing human being.
Okay. And does a living trust avoid estate and probate taxes?
I'll come to the taxes part. Yes, a living trust is supposed to avoid the probate process. So if you have a living trust and it has, say, a piece of ground out in Coffee County, Kansas, and the trust says, I want it to go to my nephew twice removed upon my death, then the trust would distribute that automatically, meaning that that nephew or the beneficiary or whoever the family members are that are that successor trustee of the trust, they would hand off that real estate without having to go through the probate process where you hire an attorney. You go into probate court, have a judge issue an order, a formal order passing that real estate along to whoever our beneficiary is. So you skip that entire process, which in and of itself can be quite expensive, depending on how good your attorney is at billing you. As far as taxes are concerned, a trust, in most cases, now I don't want to be paint with too broad of brushstrokes here, because there may be instances where a trust could save you some money in taxes, but those cases are more extreme. Generally speaking, a living trust, it will allow you to avoid the same types of taxes that you would normally. So here in the state of Kansas, if you were to pass away and you left money or land or any number of assets to your loved ones, chances are, in the majority of cases I've seen, you're not going to have to worry about any taxes whatsoever. There really aren't any death taxes that matter to the majority of Kansans. In the state of Kansas, we don't have a death tax. So if I was to leave my kids $1 million, they're not going to pay a dime in gift or estate taxes. And the same holds true by and large from the federal perspective as well. You need to really have more than $5 million per spouse before you start wandering into the territory of gift or estate taxes on the federal government side of things. And I would always encourage people, if you have an estate that's worth more than, say, $3 million, it probably couldn't hurt to have that discussion with a tax professional and an attorney that's familiar with this topic, just to make absolutely certain that everything's in order, because there are very significant tax savings that you could, or at least avoid the headache of kind of shifting those to your kids, just by doing a little bit of planning ahead of time. But a revocable trust really doesn't do anything to change, or excuse me, a living trust doesn't really do anything to change the tax perspective for your beneficiaries here in the state of Kansas. Now, with that said, there are a type of trust, a type of irrevocable grantor trust that can change very significantly the types of taxes that your family may be facing, depending on the nature of those assets. These types of trusts are typically only employed for very serious long-term care or Medicaid planning, which we talked about before. And again, the bottom line is, when you're doing that type of planning, it's extremely important that you consult with properly licensed attorneys and tax advisors who are familiar with this topic.
How do I create a living trust?
Well, the easiest answer, of course, is to pick up the phone or set up an email and reach out to an attorney who does regular estate planning work. A revocable living trust here in the state of Kansas is a pretty straightforward process. It really is something where I do not encourage people to try to look online for forms, just because, like with a will, there are a lot of moving pieces. And it's important that you rely upon the experience of an attorney, not because the attorney is necessarily trained in the will, trained in law. It's that the attorney has the experience to know what the pitfalls are that you should be looking out for. I think your earlier question is a good example of that. An attorney experienced in estate planning is going to know that they could draw up the best legal document in the world, but it's not going to do anybody any good unless they create proper electronic copies or make sure that the right people have copies of all the information that's necessary. So, and you don't get that type of guidance and expertise when you're consulting a form that you get from Office Depot or download from the Internet. So I always encourage people, if you want the luxury and benefits that come with having a good trust in place, you need to be willing to work with an attorney who can bring their expertise to bear, because unfortunately you cannot take advantage of many of the benefits of having a trust unless you've got a team of experts led by tax professionals and attorneys.
Absolutely, and we're going to take a quick break for a word from our sponsors. We'll be right back to talk more about wills and trusts and how you should go about getting that all taken care of.
Southwest Topeka has a good neighbor. State Farm agent Jim Garrison, now at 29th and Urish. If your current insurance situation has you going around in circles, get off the roundabout and stop in and meet Jim and his wonderfully efficient staff. Let Jim Garrison give you a quote and make the Garrison comparison. He's confident that with State Farm's competitive rates, the right coverage, and his unmatched service, you'll want to make him your new insurance agent. Like a good neighbor, State Farm is there, and Jim Garrison is there for you, northeast of the roundabout at 29th and Urish.
When someone has a passion for what they do, it comes through in the product they provide their customers. Just ask LaRocco's Pizza's new owner, Jason Johnson, about their crust. They make it every day and let it rise for a minimum of 24 hours before they use it for their pizza. And his staff doesn't want to do anything they won't be the best at, and you can taste it in their pizza. LaRocco's Pizza, just a half block north of the I-470 and Gage Boulevard exit. Come taste the difference.
At SportsMomsUnited.com, we celebrate every athlete and support every sports mom. SportsMomsUnited.com is on a mission to put logic back in youth sports. When you ask young athletes why they play sports, their number one answer is fun. For them, that means being on a team, making new friends, having a good time, all of which are awesome memories. We add to the memories by featuring an athlete of the day and sharing their story. Nominate an athlete today at www.sportsmomsunited.com.
Thanks for joining me again. This is Carrie Brown, Associate Broker with eXp Realty and the Preferred Advisors team, and you're listening to Real Estate 101. I am back with Scott Sexton of the Law Office of Scott Sexton. Thanks for joining me again. He's been my co-host for the month.
Well, thank you.
Okay, so before the break, we were talking about utilizing the experience and not going online to do it. So I'm going to put in a little real estate plug. Buying for sale by owner can be just a normal experience and no major pitfalls, or it could be an absolute nightmare. So it's the same thing. You were talking about utilizing the experience of the attorney. We see so much in what we do that we're not walking through it with blinders on. You know, if someone's acting a little odd, we're going to pick up on it. If something doesn't look right, we typically will pick up on it. And if we're forgetting something, or if there's a conversation that's not happening, we're going to know to pick up on it, especially if we've been in the business for a long period of time and we've been exposed. Same thing with attorneys. Obviously, you don't want to find out that you were not given access to a very knowledgeable person when you needed it most.
Well, to be fair, I think it's more important that you have a good real estate agent than a good attorney, just because if I make a mistake on a for sale by owner, I've got to live with that mistake for the next 30, 40 years. If I make a mistake with my estate plan, I'm not the one that has to worry about that when I pass away. So
there is that.
I think it's I think that is a point well taken, and one that I cannot emphasize enough. I run into a lot of transactional issues just being an estate planner, and you will spend more money correcting mistakes or issues that fall through the cracks on a bad real estate deal for a much longer period of time, and it will ultimately be more costly in most cases than a slip-up on an estate planning issue. Estate planning issues can, while it's never fun to have to deal with those, there's a lot of cleaning up that can be done. You're not oftentimes not stuck with what has happened. There are always options to get the right result, and that's not necessarily the case in transactional law a lot of the time. So I always encourage people, if you're thinking about any type of transactional work, especially with real estate, get a professional, get a real estate agent, get somebody involved that knows what they're doing, because it's just not worth the headache and heartache that comes with that type of a problem.
Absolutely. And I'm not saying that new agents cannot be successful either. I don't want somebody coming after me after that statement. As long as they've got a good broker that's had a lot of transactional experience, or a good mentor. I mean, I mentor people in our company and other companies all the time, just because I've been exposed to so much. And you learn by exposure. And
exactly.
That's just the way it is. Okay, so do you need a will if you have a living trust?
Maybe. How's that for a lawyer answer?
Always.
More seriously, anybody that's drawing up a trust, in all likelihood, you are probably going to have a will drawn up at the same time, especially with living trusts. Whenever I'm looking at a living trust, in the vast majority of cases, I will also recommend something called a pour-over will, which is a type of will that's designed kind of as a fail-safe. So if I'm doing my job perfectly, I am moving all of a client's assets into their living trust, or setting up a plan to make sure that all their stuff ends up in that trust one way or the other. Being an attorney, I'm also very paranoid, and I have to assume that there's probably stuff out there that falls through the cracks. And so I want to make sure that if there is anything that falls through the cracks, I have this pour-over will, which basically says if I pass away and there's an asset that didn't get moved to my trust, I want this pour-over will to roll that asset into the trust. Now, there are other ways that you can do that or accomplish the same end result, but having a good pour-over will strengthen your ability to make sure that those assets end up in the right place and you minimize any potential costs. So as just sort of almost a reflexive thing that I don't even think about anymore, in almost every case where you have a revocable trust, you definitely want to have this pour-over will. Now, if you have a traditional will that goes along with that trust, it can be helpful as well. So it's not a bad idea to have one type of will or another, even though you never want to use those wills.
Absolutely. I know I'd had Vern Jarbo on once before, and he gave an example of, he sat down with the client, and they gave this list of everything that they owned, and they own multiple properties. And on that list, they included, he was like, listen, it's all right here. Everything I have is here. He forgot his homestead. And so, things like that, they happen. Usually when you're thinking about this, it's obviously an emotional period because something has probably prompted you to think of, okay, I need to get this done. Because, let's face it, we all try to procrastinate things that we don't really want to do. And so, you're not always in the clearest of head, and that just literally slipped through. So it ended up, if I remember the story correctly, and hopefully Vern's hearing this and he can set me straight, but I do believe it was, it had to be probated. And so, just making a list when you're in a calm, cool state of mind and you're not having to think about, okay, something might happen, is probably the best time. So procrastination probably, it'll serve you well to not be procrastinating.
Absolutely. The joke I oftentimes will lead with folks is that nobody ever comes to see the attorney when you're having a good day. You're usually driven to the attorney by something. My spouse passed away. Mom's in a nursing home. I'm worried about my brother taking all of my mom's stuff. Those types of things are what drive clients to us, and because they're under stress and pressure, it's very easy to forget, oh yeah, I've got this asset over there. And more commonly, especially since I deal primarily with seniors, a lot of the time, through no fault of the clients, they forget that those assets are out there because they're also suffering from any number of health ailments which may impair their ability to recall all of the things that they own and what they may have bought or purchased or received 30 years ago. I mean, it's perfectly understandable why people would forget those things, but if at all possible, that's again why you have those backup fail-safes, just to make sure that inevitably when those items come up, we've got a plan B in place already.
Absolutely. And a lot of times, just an odd coincidence, my grandparents had an insurance policy on their children, which would have been my father and my uncles. And nobody had thought about, they did that when they were kids. And it had sat out there all those years. I mean, it was a flat pay kind of thing back in that day whenever you actually had those things. And it just randomly showed up. You would have, I can't imagine during his lifetime, from the time he was probably, I think they said somewhere around 14 years old, to when he passed, which was 58, which was really young. Getting younger the older I get. But to remember that, who remembers that, you know? So there's still things that you just, I don't know that there is a fail-safe unless mom and dad kept an amazing record binder or something that you would even know. So you can't get it all. But you're right. A lot of times it's, dementia start to set in and you can only recall what you can recall. So there is no real fail-safe unless you start when you're younger and just have amazing records.
Yeah. And nobody does that.
Yeah.
Not when you're young.
Every once in a while I go into a house and they have the most impeccable records. And I swear, I always joke I can hear the choir sing because it's like, oh my gosh, it's all right here.
I always ask where the bodies are hidden. So.
I don't want to know. Don't tell me. You're going to make my job hard if you tell me. I think that falls under things I must disclose. Okay, so we've got a few minutes left. What are your words of wisdom? What would you say, hey, no matter what, if you could just do this?
Probably said this every week so far, but the most, and I'm absolutely serious, the most important thing is to communicate, and don't just assume that everything's going to be okay. The families that ask questions aren't being a nuisance. They're not being a bother. Those are the ones that have the happy endings, that have the good results, are the ones that are willing to ask the questions. So as long as you're comfortable not being content and being that squeaky wheel, not just to the attorney or of the other professions, but to your family as well, make others aware of what your wishes and desires are, because the sooner and the earlier and the healthier you are that when you're making those types of inquiries, the better the end result. I cannot tell you how often I hear the familiar refrain, if only we'd done something 5 years ago. I hear that probably 85 to 90% of the cases I work on. Inevitably, someone will say during the course of the case, if only we had started this X number of years ago. Don't be that family. And unfortunately, that family is the vast majority of us. So the crowning takeaway, I think, from, if you remember nothing else I have ever said to you, take that away. Never be afraid to ask questions, and always feel free to reach out and ask for information from attorneys. Be a part of the conversation, because the more involved you are in asking those questions, the younger the better your end results will be, because the good news is that nobody has to die truly penniless and heartbroken. There are always options out there available for folks. If you have goals and objectives that you want to accomplish and you want to have peace of mind, there is a way to make that work. You just have to ask questions for the people that are out there to help you. So
Absolutely. And if they want to get a hold of you, how do they get a hold of you?
The best way is to give our office a call here in Topeka. We're at 785-409-5228. You can also reach me on the web at scottsextonlaw.com.
And if you're looking to buy or sell, be sure and give us a call at 785-213-5188. Check out our website at preferredadvisorsteam.com. And thanks for listening to Real Estate 101.
Thank you for listening to Real Estate 101 with the Carrie Brown team from Preferred Advisors.